Hello everyone. So welcome back to my English Law channel. So this is a lecture about criminal law, looking particularly at non-fatal offences against the person. So this is mostly governed by the Offences Against the Person Act 1861, which is a real watershed in criminal law. When it says the person in this case, it means the body rather than meaning the human. So the human body in general, that being attacked, because offences could be crimes of any nature, but we mean a physical attack. So there are all kinds. There's assault and battery. So Section 47 of the Offences Against the Person Act talks about assault, occasioning actual bodily harm. We're going to go through these bit by bit, defining them more clearly. So we often abbreviate it as OAPA, Offences Against the Person Act. Section 20 has got wounding or inflicting grievous bodily harm, GBH, it's often abbreviated as. Section 18 is about wounding and causing GBH with intent. Section 23 is about poisoning someone with the objective of putting the person's life in jeopardy. Now, odd that they don't say with the aim to kill the person, but sometimes it's difficult to prove that the defendant actually wished to kill the person, but they wish to risk the person's life. That's a lower evidential barrier to clear. So that's why it's phrased that way. Poisoning someone with the aim of endangering life. And Section 24 is administering poison with intent, as in not by accident. Otherwise, food poisoning in a restaurant, poor hygiene would be this crime. Now, having poor hygiene in a restaurant, giving people food poisoning is a crime, but that's a different one because we're just saying that the restaurant was negligent in not cleaning things properly. But this is when you deliberately poison someone, not trying to kill them, but just to make them ill. Okay. So anyway, so assault and battery. Well, these are both common law and statutory offences. The Criminal Justice Act 1988, Section 39, defined them, but these were crimes under common law beforehand. So assault, this is in Fagan against MPC as a Metropolitan Police Commissioner. It was decided by a judge with the surname James. Well, James, he defined assault, the Actus Reyes thereof, as the following. An assault is an act which causes another person to apprehend immediate and unlawful personal violence. Close quotation. Personal meaning on the body, not kind of individual as such. So the thing is, the assault doesn't actually have to hit someone. It has to. If you hit them, then that obviously is assault. But if you even put them in fear of it without actually hurting them, that can still be assault. So threatening gestures or verbal assault. So I'm about to punch your lights out. That would also be assault, even if you don't go on to then do it. So any act can include words if they're sufficiently clear and sufficiently threatening of violence. So as in R against Mead and Belt, or R against Wilson, R against Ireland. So remember, it has to cause the other person to expect physical violence. So the way they would use the word apprehend here, rather archaically, means to believe, to think that they're going to be hit, kicked, punched, stabbed, anything like that. So carrying on the Actus Reyes. But what if the victim, or supposed victim, doesn't believe that violence is going to ensue, as in R against Lamb? Well, then that seems like it's not assault. And what if the defendant is making the threat, but will be unable to actually commit any act of violence, as in Logden against DPP? So again, that's probably not assault. What if the victim is exceptionally weak or touchy, easily frightened about threats? Does that mean that something which wouldn't be assault against an ordinary person is a threat against this person because he's such a scaredy cat? Well, no, there's an objective standard. Now, it said that words can cancel out the threat as per Tuberville against Savage. So remember, it has to be personal violence, as in against the human body. It can't be vandalism against an inanimate object. It can't be violence against an animal. So this is as in R against Ireland and Burstow, another case. So the Actus Reyes, remember, it's got to be immediate personal violence in the next few seconds, in the next few minutes. It can't be going to get you tomorrow or in a month. So this was just held in Smith against Chief Superintendent Woking Police Station, or indeed R against Constanza, or an Ireland against Ireland. Remember, it has to be unlawful violence, because people are allowed to use force, or to use more pejorative word, violence, in self-defense. There's certain situations where you could successfully advance a justificatory argument for the use of violence. The police and the armed forces are, under certain circumstances, permitted to use violence with contemplation, a forethought. So let's look at the mens rea as in the mental element of the crime of assault. Assault is any action which deliberately or recklessly causes another person to believe he is going to suffer immediate and unlawful personal violence. That's per Fagan against Metropolitan Police Commissioner, or indeed R against Venner, R against Savage, Parmenter is another one. So battery. So what is battery? In Fagan against MPC, that Judge James defined it thus: a term used to mean the actual intended use of unlawful force to another person without his consent. Okay, so battery is usually a bit more serious. I'm going to batter you, that kind of thing, a bit like a battering ram. So anyway, so it can be reckless as well, this use of force. It doesn't have to be entirely purposive. So the Actus Reyes of battery is using this unlawful force against another person, as per Fagan against MPC. Now, that could even be touch under unusual circumstances, as in Collins against Wilcock. Touching clothes can be this, R against Thomas. It doesn't necessarily have to be with malice, as in Faulkner against Talbot. They described that they said there was no hostility there. So it can even be the indirect application of force, as in Haystead against Director for Public Prosecutions, or Director of Public Prosecutions against Kay. So in battery, the Actus Reyes can even include the failure to act, as in Fagan against MPC, as in driving your car onto a policeman's foot accidentally, not intending to injure him. Then it is on the policeman's foot, but he's like, "You're on my foot, get off, reverse your car off." Now I'm hurting him. I'm not going to, because it was believed that these crimes of violence couldn't be committed by omission. He didn't deliberately drive it onto his foot. Yes, he drove his car, not realizing it was going to go onto the police officer's foot. But once it was on it, well, I'm not doing anything. By not reversing, that's not carrying out an action. Therefore, there is no Actus Reyes for assault. But as held, know that an omission in this case could be a crime. Usually, omissions can't be a crime. Usually. There are exceptions when an omission is a crime. For instance, not paying tax, not answering the census, not caring for your child, and so forth. R against Santana Bermudez is another case that proved that battery can be committed by an omission, as in not doing something. All right, so remember, battery is unlawful. If the person consents, then it's not unlawful. Volens non fit inuria, as in the willing are not injured. I mean, they can be physically injured, but it's not an injury in law. So as in Collins and Wilcock, there was implied consent. There was a case in the early 90s where some homosexualists got together for some sadomasochistic activities, and they agreed to them, but these were thought to be so extreme that even though they agreed to them, their consent was vitiated. But if people want a light spanking or something like that, some flagellation, that would be permissible. Or things like a boxing match or sports matches where people bump into each other, hurt each other a bit, because they've agreed to it through this sport, that shan't be assault so long as they do it within the rules. If they go outside the rules, as in punching someone in football or something like that, or